Good evening, ladies and gentlemen. Thank you all for braving the rain, and welcome to listeners on Aspen Public Radio. And most of all, a welcome to you, Justice Kagan.
Great to be here.
And I think you told me this is actually your first time in Aspen.
It is my first time, but it's not going to be my last.
Well, we like to hear that.
It might be pouring down, but when I left Washington, D.C., it had just set a record for heat, which, you know, in Washington, D.C., that's pretty high. So it's great to be here. And it's great to be here in this terrific community, and I've been taking advantage of the music and all the beauty, and it's a wonderful place.
Yeah, comparing notes on hikes. So many of you will be seeing her on the trails for the next few days, and we're going to take very seriously your offer to come back as often as possible. In a 1998 profile of the young Elena Kagan, still very young, after having been promoted from the White House counsel's office to the deputy chief of domestic policy in the Clinton White House, she was described as the White House's all-purpose brain. An advisor to the president on all things legal and constitutional, she developed a reputation that just grew over the years of being able to bring together people of diverse ideological positions with enormous skill. In the White House, for example, she was the one who convinced John McCain and the Republicans to allow the FDA to have regulatory authority over tobacco, which was not a mean feat. After her experience in the White House, she returned to her roots in the law. She had been an editor of the Harvard Law Review, clerk for Justice Thurgood Marshall. She returned to Harvard Law School, where she became a professor and then became dean, I think the first woman dean of Harvard Law School. And interestingly, there again, she became highly regarded for her ability to bring conservatives and liberals together in what was a very highly fractured faculty, and recruiting many conservative voices to a faculty known for its liberal reputation. She was appointed the Solicitor General of the United States by President Obama in January 2009, and I think I'm correct to say that you were also the first woman ever in that position.
That's right.
And then, of course, she was nominated to be an Associate Justice of the Supreme Court by the President and was sworn in just about a year ago this week. And she has now, of course, completed her first term. When she began on the term, there was a lot of discussion about how there'd be havoc because of all the opinions that you'd have to recuse yourself from having been Solicitor General, perhaps a third of the cases this term. But there really wasn't that much difficulty, as it turned out, with those cases, was there?
It turns out that I was not indispensable. The court managed without me perfectly fine. I was recused from about a third of the cases, about 30. 28 of them were the other 8 justices managed to decide. On 2, they split 4-4. But that's a pretty small number, and the only thing it really made me think was I appear to be expendable as the ninth justice. Next year I won't be recused in so many.
Well, we'll talk more about the term in a minute. And even though it was just her first term, and even though there were recusals in the third of the term, I think it's fair to say after this term, and as we'll discuss more, she has received extraordinary high acclaim for her opinions in this first term and her influence. And indeed, Linda Greenhouse, who's probably the dean of Supreme Court reporters and now a professor, actually wrote that Justice Kagan was the term's biggest winner, which is really remarkable for someone who was just in her first term. But let's start with questions about the expectations you had about the position, given the kinds of experiences you had before. You're the only member of the court who had no prior experience of being a judge. What did that mean for you? Were there things you had to learn that your brethren did not?
I think that there were. I'll separate out two things, because I think all justices, when they start, find some things difficult, and it doesn't really matter whether you've been a judge or not. My good friend and colleague, Justice Sotomayor, has talked about this. She had been a judge for umpteen number of years, but she said that the experience of judging on the Supreme Court was different, just because all the cases were so much harder. They don't get to the Supreme Court unless they're very, very difficult, and because you don't have any kind of backstop. So the decision you make is the final decision, and that certainly increases the sense of responsibility and the pressure. And so I think even when you come from a circuit court, there are real differences in the experience of being a justice that a number of my colleagues have talked about. But there's no question that because I had never been a judge before, there were some things that I had to figure out that all my other colleagues had already figured out. So that was certainly true of what I'll call the mechanics of the job. All my other colleagues, they had been judges before. They knew things like, when it was most valuable to them to read the briefs. Do you read them 3 weeks ahead of the argument, or 1 week ahead of the argument, or the prior day? And people have very different styles in this respect, and they had figured out what to do. Or the question of how you deal with your clerks, what you ask your clerks to do, what functions your clerks perform, exactly how you write opinions. Do you write the first draft, or do you ask the clerks to write the first draft? And if you ask the clerks to write the first draft, what do you do with it exactly? So all of these questions, the mechanics of the job, I had to figure out, and to tell you the truth, I'm not sure I have. It was I used to say to my clerks that their experience clerking for me was probably different than any clerks I'll have in the future. In some ways more exciting because I was trying to figure this out, but in some ways frustrating. That my clerks, I think, sometimes I would say to them, well, why don't you go do this? And then they would do exactly what I said. And then I would say, well, that was a waste of time for all concerned, What was the point of that exactly? We have to change that one. So it was, in terms of the mechanics of the job, it was a little bit of trial and error and trying to figure out what worked for me, how I learned best, who I wanted to talk with when I wanted to read what, all of those things. I think, I was definitely just trying things and seeing what worked for me, and I expect I'll continue to do that.
What about the fact that you had spent so much of your career as a scholar in the academy? Did that affect your experience in ways that perhaps surprised you?
I was thinking about this recently, and this is what I think. I think it occurred to me at one point that I approach writing opinions in the way I approached preparing for a class. So the way in which the teaching experience actually was most relevant to my judging was not the scholarship part of legal academia, but was the teaching part of legal academia. That I used to, I think what makes a good law school teacher is not how much you know. Everybody knows a lot if you're a professor at a law school. But trying to figure out how to communicate complicated ideas to people who know a lot less than you do about a given subject. And not only how to communicate them so that they understand it at the moment, but also how to communicate them so that the points kind of stick with them, trying to figure out vivid ways of explaining things that stick with people and that make them look at a subject in a particular way. And I realized one day while I was sitting writing an opinion that I was going through the same kind of process, really trying to figure out how would I teach this class, and if I could figure out how I taught the class to make people really get something, then I could figure out how to convey the ideas in an opinion to make the readers get that thing.
And what about your experience as Solicitor General? You argued 6 cases before the Supreme Court. How did that help you in your first term?
Well, for one thing, it gave me a lot more sympathy with the people on the other side of the podium. I share this with a few of my colleagues. A number of them have argued before the court. The Chief Justice is, may have been the best oral advocate in the history of the Supreme Court. So he has had a great deal of experience. Justice Alito has, Justice Ginsburg has. And I think it does give you a sense of what they're up against. It's a lot easier to ask the questions than it is to answer them. It's like I was reminded here of the thing that a lot of law professors say to their classes. They say, it's just as hard to write the exam as it is to take it. And truly, that's no. And that's the same thing here. But being Solicitor General, I think, gave me just a great perspective on the court. In some ways, the job that's most like being a Supreme Court Justice is being Solicitor General. You're not deciding the cases, but you are focused all the time on the Supreme Court. Your job is to try to figure out how to persuade 9 Supreme Court justices to take a particular position. And now my job is to figure out how to persuade 8 Supreme Court justices. And really the difference between those things is, not altogether great. But the Solicitor General, for those of you who don't know, I know a lot of you aren't lawyers, the Solicitor General is the lawyer who represents the United States in the Supreme Court and who also supervises appellate litigation generally. And the Solicitor General actually participates in about 3/4 of the cases that the Supreme Court decides each year. So if the Supreme Court decides 80 cases, the Solicitor General is participating in 60 of them, sometimes as a party and sometimes as what's called an amicus curiae, a friend of the court, somebody who's not a party to the case but who has some interest in how the court rules on the case and so participates in the court's decision-making. And when the Solicitor General participates as an amicus curiae, it's almost always given argument time, and in fact is treated almost as if it were a party. So in about 3/4 of the cases during the time I was Solicitor General, I was there, and I was watching the lawyers who worked for me argue to the court, sometimes arguing to the court myself. About once a month I did that. And watching the justices and trying to figure out what they were concerned about and what their questions were all about and what it showed about their various interests. And so you learn a tremendous amount about the court by doing this job, which just has, the job is to focus on the court and to try to convince the court to do things.
Let's bring you back to your very first Supreme Court argument, and if I'm not wrong, it was a case called Citizens United.
Big case.
And tell us what it was like to argue that case. Then I'm going to ask you what it was like to hear the decision.
So it was obviously a big case, and it was, as you said, my first Supreme Court argument. It was actually my first appellate court argument of any kind. I had argued in district courts as a younger lawyer, but I had never made an appellate court argument, so that was a little bit nervous-making. And then it was this big case. The case had been argued, the term, so I forget what the years were, but the prior term. And it was argued by a wonderful lawyer in the Solicitor General's office. And he argued it the day after I was confirmed by the Senate. So I was confirmed by the Senate, and I went to my job on my first day, and the first thing I heard was this wonderful lawyer in my office arguing Citizens United. And I think he would be the first person to tell you that argument did not go well. And so everybody thought, well, we're going to lose this case. But then the weeks went by, and the court didn't issue any decision. And then on the last day of the term, the court, rather than issuing a decision, issued an order, and it was an order to rehear the case the next year, something that the court very, very, very rarely does. And accompanying this order was a set of questions that the lawyers were supposed to focus on the next year. And basically what the court said is, we want everybody to argue about whether the court should overrule 2 prior Supreme Court decisions. And when the court does that, you know, when the court says, we're going to rehear this case and we want you to tell us whether you think we should overrule 2 prior Supreme Court decisions, I think it does not take a great Supreme Court expert to say the court is pretty much there. You know, that's, you know, they're pretty much. So as the summer went on, and it was clear that because I was Solicitor General, I was going to argue this case to sort of, you know, take it over. And it was an important case because it was any time the Solicitor General's office decides to defend the constitutionality of legislation, it's important. But this was very important legislation. This campaign finance law had been in the making for many years. It was an extremely important piece of congressional legislation, and my job was to defend it. And the only thing that made it a little bit less nervous-making was that everybody I talked to said, well, you know, you're going to lose. Really doesn't matter what you do up there, just like have a good time. But I worked hard. I prepared hard that summer. And I went up and argued as one of 4 lawyers. And, you know, I was nervous when I sat at the bench, but when I got up to the podium, the words started coming out of my mouth, and I thought, okay, I can do this, I guess. And actually, it was a very thrilling, exciting experience. But it was also clear to me when I sat down again that all those people were right. You know, I was going to lose. There was no 5th vote out there. So I wasn't all that...
So there was no surprise.
I was not all that surprised.
So let's talk about a different kind of surprise. Given all of your experience before studying the court, arguing before the court, now being one of the 9 justices, what was your biggest surprise, actually, you know, being a member of the court compared to what you expected the institution to be like?
Well, you know, I'm not sure it was a surprise, but it was but I suppose just how warm everybody is, how collegial the institution is. And I think that this comes as a surprise to many people when I talk about my experiences on the court, and to me as well. You know, you read the court's decisions, and often there's some pretty sharp give and take. People accusing other justices on the other side of a wide variety of terrible conduct. And you kind of think, my gosh, they must hate each other. You know, if they didn't hate each other before they wrote that opinion, certainly they're going to hate each other after they wrote that. And the truth is, it is completely not so. It is an incredibly collegial and warm institution with good friendships sort of throughout the court and across whatever people think of as ideological divides. And that was the sort of nicest surprise, or just the nicest feature of joining the court, was feeling that, what a warm welcome people gave me, but also just how warmly people feel toward each other, and how well and respectfully the members of the institution operate together.
Well, why do you think that is? I mean, it's really remarkable, and when you consider the kind of partisanship and lack of collegiality across the street, you know, one would hope that there might be some way to bottle this. And I wonder if one of the reasons actually is that everything you do is in writing, and it's all reasoned, and there's a certain, even if the language is strong, there's a degree of mutual respect even across the divide, whereas maybe our more political branch, or our political branches now exist in, you know, sound bites, and things aren't reasoned and argued, and they're just conclusions. But whatever, why do you think it is like that? And I was a law clerk there. I remember how collegial it was, and it was a shock then, and it still is that way despite the appearance of ideological divides.
Right.
And it's wonderful, and too bad it's not contagious.
Well, you know, I don't know. Your theory is an interesting one. I hadn't thought about that. I mean, it's an interesting one in part because sometimes the writing makes you think how could they really like each other after that? But you're exactly right that it's not, for the most part, sound bites. It's reasoned argumentation. I don't know, I think some part of it may be just luck, because although when you clerked it was collegial and now it was, there have been times in the Supreme Court's history when it hasn't been so. I read a great book about the Supreme Court in the 1940s and 50s recently called Scorpions.
Noah Feldman's book.
Yeah, exactly.
Yeah, he was on this stage.
Oh, is that right? Well, it's a fabulous book, but it really makes you feel that you're lucky to having this collegial court, because the court in those days, and he focuses in particular on 4 justices, all of whom were appointed by FDR. When they were appointed, they were thought to be sort of natural allies, and they hated each other. I mean, their relationship was pathological.
Scorpions in a bottle.
Scorpions in a bottle. So, partly I suppose it's probably just luck and contingency. But, the other thing I've thought is that, boy, we know we're going to be dealing with each other for a long time. The minute after the Senate confirmed me, the first phone call that came into me was from the Chief Justice. I took the phone call and he said, I wanted to be the first to congratulate you and to tell you how excited I am to serve with you. And he said, we're going to be serving together for 25 years. And I said, only 25? and it's true. And I think that makes people, I don't want to say it's like you have an incentive to like each other. I think it's just, you can live in an institution happily, or you can live in an institution sadly. You can live with people respectfully, or you can live with people, without that. And if you're going to be someplace for a long time, it makes you value collegiality.
I think it's fair to say that the Supreme Court is by far the most respected institution in government today. Certainly it's true today. Yet it's also the least understood.
I hope that's not related.
I hope not too. But why?
If they knew more about us, they'd dislike us more.
Well, actually, in that context, if they'd know more about you if you allowed cameras in the courtroom, as we have here. Do you think that would be a good idea?
Well, with the cameras, with the lights glaring in my eyes right now, I think the answer is clearly no. But actually, I've said before that I do think it would be a good idea, and in this I differ from some of my colleagues. And in this last year, I have come better to understand the opposite position. But I guess the reason that I've thought that I came to this view really when I was Solicitor General, and I was sitting there, as I've said before, just watching case after case after case, and this is an unbelievable court to watch, actually. So this was the court before I got onto it. It was, everybody was so prepared, so smart, so obviously deeply concerned about getting to the right answer. I thought if everybody could see this, it would make people feel so good about this branch of government and how it's operating. And I thought it's such a shame, actually, that only 200 people a day can get to see it, and then a bunch of other people can read about it. Because reading about it, I think, is not the same experience as actually seeing how these, it's an incredible court, the court that I watched, just in its level of preparation and engagedness and intelligence and real concern. And I thought it would be a good thing to, but some of my colleagues disagree, and the reason they disagree is because they're worried that would change. And they're worried that if you put cameras in there, everybody will start playing to the cameras, and that the actual, thing that's so good about the institution will diminish. And that's a fair point. And I think I'm still coming out with trust that actually we would continue to do the same thing, and that lawyers would continue to do the same thing. But I understand the concern.
in the spirit of greater understanding of how the court works, I wonder if you could just take a minute and talk to us about how the court decides, and particularly from the perspective of the junior justice and you know, the significance of oral argument, and then describe the conference where, as I understand it, as the junior justice, you have to give your opinion before anybody else does. If you could just walk us through that.
Oh, I wish it were that. It's actually the opposite. I go ninth. And I think that this has changed over time.
Yeah,
so
I think it used to be the other way.
Yes. So I go ninth, and let's start there, and then we can talk about oral argument. The Chief Justice starts in every case, and the Chief Justice sort of introduces the case, and then says what he thinks and how he would vote. And it goes around the table in seniority order, and I'm the last to speak. And there's a rule that nobody can speak twice before everybody has had a chance to speak once. And you kind of think, well, that's a sort of artificial and formal rule. But let me tell you, when you're the ninth justice, it must have been the ninth justice who thought up this rule. So we all go around, and after I speak, then actually, you know, the ninth is not so bad. Like, I think the ninth is actually better than the eighth or the seventh or something, because there's a certain drama sometimes to going ninth. It just rarely, but you know, you can. But then there's a more general discussion, and the general discussion varies. Sometimes it can be very quick, and sometimes it can be very lengthy. It's not tremendously related to the importance of the case in the public eye. I mean, you might think. I remember my first conference. And there was a case that, you know, was clearly a kind of front page newspaper case, and we voted, and then we all went around, and then we just discussed it a little bit, and then there was another case which no newspaper in the United States would write a sentence about, and we discussed it for 40 minutes, and I thought, well, why is that? That seems a little, but I think the discussion is relative to. I mean, we discuss when we think there really is something to discuss, and that votes might change, and that the consensus might be reached. And you know, there are some cases where, in the end, you go around once, and it's pretty clear that everybody thinks what they think, and you can discuss it till the end of time, and it's not going to do anything except make people madder at each other. But there are some cases where discussion really, really helps. It changes minds. It forges consensus. And there we talk a lot among each other to try to do that. So that's the way conference works. Oral argument comes a few days before conference, so we actually have time to think about the oral argument, to think about what we learned, and to think of. And I find that very valuable. There are some courts where the judges go straight from oral argument into conference. But I find it very valuable to actually digest what has happened in oral argument. And that's both to think about what the lawyers have said to our questions, but also to think about what my colleagues have said. Because a large part of the value and the function of oral argument is to listen to each other. Because oral argument is actually the first time the justices talk about a case together. And so when Justice Scalia or Justice Ginsburg asks a question, I can figure out what's bothering them about a case and where they're leaning. And that can be extremely valuable to think about, both because, you know, it may be convincing to me, and also because, you know, it may help me to try to figure out how I can convince them. So oral argument, I think, is an important part of our process.
Chief Justice Hughes said about the time in the 30s, somewhat famously, that it takes 5 years to go around the track once here, meaning that it takes a long time for a new justice to sort of find, at that time it was all his, find his voice, find his influence. And I think it's fair to say, reading Supreme Court commentators after your first term, that you're not taking 5 years. That in only 1 year you've had quite a remarkable influence. I mentioned already that Linda Greenhouse said that you were really the winner of the term in terms of the significance, particularly of a few dissents, and we'll talk about
I lost those.
You lost, but they're for posterity, and someday they will be convincing. And then just this last week, Jeff Rosen wrote in the New Republic that one of the remarkable things about this year was, and you'll probably blush, but the elegance and eloquence of your prose, and how you have emerged as such a beautiful writer and a convincing writer, and how in his view as a student of the court, it usually takes a very long time to be able to reach that point. And he even compared your dissents to those of Holmes and Brandeis.
Showing he has no credibility whatsoever.
Well, we don't think so. And actually, if I read some of the excerpts from those dissents, it'll actually bring some context to what you said earlier about after saying some of the things about the other opinions, because they're very forceful. But the other thing that Jeff said is that you write in a way that is so understandable for anybody. And that when I got a chance to read these dissents before this opportunity to interview you, and one of the things that I think is a great shame is that I think most Americans think the Supreme Court opinions can only be read by lawyers, but they're really remarkable. And let's just talk about a couple of them. Let's talk about this term. There are two cases that you wrote very strong dissents, both involving Arizona. And one of them, the Arizona Citizens Clean Elections Act, was one in which the Chief Justice wrote the majority opinion. And you had some very, very strong language in your dissent. And I wonder if you could just describe what that case was about and why you felt as passionately as you did in dissent.
Well, it was a case about the constitutionality of Arizona's public financing system. And particularly one provision of the public financing system. The way Arizona's public financing system worked, this is, basically Arizona had decided that if all candidates are privately financed, that there will be too great a chance of corruption. With all this private money in the system, people giving gazillions of dollars, or more often these days, people bundling gazillions of small contributions, that those people will have the ability to go to a candidate and then to a representative and say, essentially, well, here's what I want you to do. And so public financing systems are meant to decrease political corruption. Arizona's public financing system had a provision which was, it worked by way of a matching fund. And at a particular point, there was above a certain floor and below a certain ceiling, the amount of money that a public financed candidate would get depended on how much money their privately financed opponent would spend. So if their privately financed opponent put on a TV ad that cost, X amount of dollars, the publicly financed opponent would get the same amount of money up to a certain ceiling. And the reason that Arizona had this system is that it's actually very difficult to make public financing systems work. Either you don't give the public financed candidates enough money to run a competitive campaign, and then people say, well, you're not giving me enough money to run a competitive campaign, forget it, I'm not joining the system. Or you say, well, in order to prevent that, we'll give you a lot of money, but then it turns out that a lot of times that's just wasting taxpayers' money because the elections aren't competitive anyway. So what Arizona tried to do was to say, we're going to give the publicly financed candidates enough but not too much to run a competitive campaign, and that this will strengthen our public financing system. Now, do you want me to keep on going?
Please, I think it's important.
The majority said that this was a restraint on speech, that it essentially burdened the privately financed candidate's speech, because the privately financed candidate would know that the publicly financed candidate was going to get money, and that this counted as a burden on the privately financed candidate's speech. And my response was that that was not the case, that the majority kept on thinking about this in terms of the language of restrictions and restraints and curbing speech, but that if you looked at this system and if you looked at the way it worked, in fact, what the legislation was doing was producing more speech and more electoral competition, and that that should not count in anybody's world as a First Amendment injury, to essentially subsidize speech. And there's a very long line of First Amendment cases, of First Amendment precedents, that say that when the government pays people to speak, that's okay, as long as the government doesn't discriminate on the basis of viewpoint, as long as the government doesn't give money to Democrats but not to Republicans. And here there was no question that the government was not doing that. Anybody could have this money if the person decided to enter the public financing system, which was the whole point of the program. So I guess the point of my dissent was really to say that the same rule should follow, that this was creating more speech, that we shouldn't view this as a speech restraint requiring a special justification, but that even if we did, there was a special and important and indeed compelling justification here, which was to reduce political corruption. And that was the dispute between us.
And if any of you have any doubt about Justice Kagan's ability to explain very clearly what she thinks of the majority's opinion.
Oh, no, don't read something that, no.
I love it, I love it, I love it. She says, against all this, the majority claims to have found 3 smoking guns that reveal the state's true and nefarious intention to level the playing field. But the only smoke here is the majority's, and it is the kind that goes with mirrors. And if you like that language...
Listening to that, I'm not sure I would have written it that way again.
Well, then I won't read anymore, because I love those dissents. Let's stay on that theme. And if any of you are interested in the other Arizona opinion, it involves the establishment of religion and the dissenting. Have we lost power? One of the speakers, I'm sorry about that. I don't know if we can do anything about that speaker, but the other Arizona opinion in which Justice Kagan was in dissent involves an establishment of religion claim, and I want to leave time for questions from the audience. So yeah, there it is again. Thank you. There were a number of First Amendment cases this term, and it was perhaps a banner year for the First Amendment. There were the victories were for purveyors of violent videos to minors, victories for what most people would consider outrageous protesters at military funerals, a victory for, as we just discussed, rich people who decline public funding, and also victory for data mining drug companies who wanted access to doctors' prescriptions. Is there something you can say about all of these First Amendment opinions to put them in context? And obviously you didn't agree with all of them.
Right. I think most of us did not agree with all of them. I'm just trying to think off the top of my head about those 4. And I think it is the case that Justice Kennedy and Justice Scalia agreed with all 4 of them, and none of the other people took the most speech protective position in all of those cases. So, and just to give you a little bit the opposite side of this, we did have some cases where the court decided against the expansive reading of the First Amendment. There was one case which dealt with the speech of public employees, where the First Amendment claim was rejected. And there was another case, a very interesting case, where we rejected the First Amendment claim of an elected official who said that various conflict of interest laws interfered with his freedom of speech. So the court didn't always vote in favor of the First Amendment claim, but you're exactly right that most of the time, and in the biggest cases it did. And I think what you have to say, and people have been saying this for a while, is this is a court that is extremely protective of the First Amendment and extremely protective of speech. And indeed, to the extent that the court sees something as restricting speech, it's likely as not going to, that restriction is going to go down. There are disagreements among the justices about what counts as speech. There are disagreements among the justices, as I've just said, about what counts as a restriction. But there's no question that this court has a very expansive view of the First Amendment.
Was one of those cases particularly difficult for you?
You know, I did find one of those cases difficult. I thought that the video games case was the toughest case that I decided all year. I mean, it was the case where I struggled most and thought most often, maybe I'm on the wrong side of this. And so this is a case, it came out of California, and it involved extremely violent video games. There was a question about how the video games to which the statute applied was defined and whether the definition was vague. But putting that question aside, the question was whether the state could prohibit the sale of video games to minors if an adult was not with the minor and didn't sort of give permission for essentially not allowing minors to buy video games themselves unaccompanied by an adult. And you can see why the government would have wanted to do this. You can see the kind of danger that it was worried about, the kind of effect that these extremely violent video games have on young people. And, you know, in some ways it was very easy to say, I understand what the state was doing here, and you know, and seems kind of reasonable. And but I couldn't figure out a way to square that with our First Amendment precedents. And precedent is very important to me. I try to think all the time about what our prior cases have said and what analysis is required by those prior cases. And it seemed pretty clear to me that those prior cases required us to evaluate the legislation by means of what's called strict scrutiny, which is to say that the state has to have not just an important but the most compelling kind of interest, and the state has to show that the legislation is advancing that interest in the most narrow way possible. And I thought that this test, that this statute couldn't satisfy that standard, and I thought that it was pretty clear that that standard was the one that had to be applied according to our various precedents. So I ended up coming out in that case, I joined Justice Scalia's opinion, which invalidated the California law. But I sweated over that one mightily.
We're going to open up to questions, so please be thinking of them. I just want to ask one more question before we do, and that's about presidential appointments. We talked earlier about how there are so many appellate judges on the court right now. There are 8 appellate judges on your court, and there are 9 who went to either Harvard or Yale Law School. Do you think there's a problem with that?
So I'll tell you a story. When you go through the confirmation process, you have these courtesy visits with all these senators. I think I had courtesy visits with 80 senators. And each of them tells you how, no, a lot of them are very, very nice. And in fact, all of them are courteous. But a number of them, they do tell you how you don't sort of match up to their idea of an ideal Supreme Court justice. And I went into one office, and the senator said to me, I told the president 2 things, he said, when the president asked me what I wanted in a Supreme Court justice. And I said, okay. And he said, the first thing I told the president was I didn't want another circuit court judge. So I said, okay, that's good. He said, the second thing I told the president was I didn't want another person from Harvard or Yale. You know, he's speaking to the dean of Harvard. So I thought, well, you know, I said to him, I hope 1 out of 2 is good enough. But But there are ways in which the court is unrepresentative. I mean, there are lots of great law schools out in the world, and there are lots of great lawyers who did not go to those two schools, and it's totally fluky and a little bit ridiculous that those two schools, have all 9 justices between them. It's also, as you said, 8 of them had been circuit court judges. Another thing that's kind of strange, I think most of us, not all of us, but most of us have lived most of our lives on the Amtrak Acela line. We basically, most of us come from, take Washington, D.C., go up to Boston. That's where we've spent most of our lives. And that's kind of weird, too. So, I think the problem is that there are so many measures of like what people think of as appropriate diversity, and only 9 seats, and the ability only to nominate people one by one over a course of many years, and it's just sort of hard to figure out how to do this, if that's what you think you want to do.
Ladies and gentlemen, we can't see, as you heard from Justice Kagan, but I do want to have questions from the audience, and I think we have microphones, and you're just going to have to help me over here. If you could just give us your name and have a very brief question, please. I don't think that mic is working.
It's working. She said it's working.
Ah.
Charlotte Robinson, Boca Raton, Florida. When is this country going to get tough on immigration, porn, and hardened criminals?
Well, I think each of those questions are likely to come before the court next year, so I'm not sure Justice Kagan can answer that. And seriously, I don't think she can answer that.
Yeah, I mean, I think we function as an institution in a very particular way. We decide cases. We don't decide big, broad issues. We decide controversies between 2 particular parties, and I think we take very seriously the idea that we really look carefully and closely at the particular case or controversy before us and the particular arguments that are made on either side of that case or controversy. And in this way, we function very differently from legislatures, from presidents, from governors, from political actors. And so we don't say, here's what I think of issue X, or here's always the way I'm going to go on issue Y. That we take really seriously the notion, we only, our jurisdiction is limited to cases or controversies, particular disputes between parties, and we focus mightily on those particular disputes.
Okay, question over here.
Yes, my name is Sir Cyril Taylor. I was High Sheriff of Greater London. Last night we had the privilege of
London has a High Sheriff. Wow.
Last night we had the extraordinary experience of watching Billy Budd. And I wanted to ask you, as a very distinguished Supreme Court Justice, in your decision-making, are you looking for the most just decision, or are you constrained by the legality and the particular constitutionality of whether something is right or wrong?
Oh, there's no question that I'm constrained. I mean, that's an easy question. I'm not a moral philosopher. And, it's funny, in a way, justice, it's a little bit of a misnomer because it suggests that what we do is sort of in each case say what's the just outcome. But we don't do that at all. We say in each case what's the appropriate legal outcome. And, it might be that we're interpreting the Constitution and we're trying to figure out what the Constitution means. It might be that we're interpreting a statute and we're trying to figure out what a statute means. Take that kind of case. Take a case where Congress has passed a statute, and a case has come to you that concerns the meaning of that statute. And you think it's a terrible statute, really. Actually, you think it's even an unjust statute, an unfair statute. Well, too bad, because your job is to look at that statute and to try to figure out what it means, putting aside whether you think it's a good or bad statute. Your job is to try to figure out what Congress meant to do when it passed the statute, and to resolve ambiguities and fill gaps in the way that you think Congress would have intended to do so, because Congress is the decision-making body here. And the same thing is true, although in a somewhat different way because of the more open-ended provisions when you're dealing with constitutional law. That once again, you are doing law. You are trying to figure out what the Constitution means, and where the text doesn't tell you that, looking at the history, looking at the precedents, but looking at legal sources to try to figure out the meaning of a particular provision that's at issue in a particular case.
We have a question somewhere. I have to rely on our runners because we can't see.
Yes, my name is Fred Cooker, and given what you said about what you had to do during your first term because of your involvement with the Obama administration, I'm wondering what you're going to do when the health care legislation comes before you.
Well, I don't announce in any case whether I'm recusing myself or not prior to that case. And there have been cases, look, I mean, I think, if you make a study of this, you'll see what I voted on before, but I never do this, and no other member of the court does this says whether one is recused as to a particular case before that case comes up.
Do we have a question somewhere in the middle?
Yeah. Justice Kagan, just following up on the point you made a couple of minutes ago. My name's Mark Silverman, and I'm a lawyer in D.C. Two distinguished justices have expressed their views on looking at authorities, both one focusing on domestic standards, the others focusing on precedent and authority of multiple countries around the world as to what should be considered in deciding opinions. I'm curious as to whether or not you have a particular view.
I'm sorry. Do it one more time. My view on whether
the standards to be applied in reaching a decision, and whether you should be looking at U.S. standard only or the international laws as they may relate to the particular issue.
Well, I mean, there are some kinds of cases where you have to look at international law. So if you're interpreting a treaty, you're looking to international law. And that's the most obvious example, but there are others as well. The cases in which this has been controversial, I think, are not those cases. The cases in which this has been controversial is when there are particular provisions of the U.S. Constitution where there is a dispute as to its meaning, and some justices have cited or made reference to foreign law in order to interpret a U.S. provision of the Constitution. Now, I guess my view is that when you're interpreting the U.S. Constitution, what matters is, I mean, we have a very distinctive Constitution with a very distinctive set of provisions, and that nothing that another country does is going to settle that question. On the other hand, I think that there are some people who would say, well, you can never cite a foreign case, or you can never at all refer to what a foreign court has done. And that seems wrong to me as well, that, in just the same way that you might cite a law review article because the law review article has a good idea in it, you might cite a foreign precedent because that foreign precedent has a good idea in it. But in doing so, you have to be really super cognizant that the foreign precedent may be interpreting a provision with a very different history and a very different tradition than the provision that you're interpreting. So I don't think the kind of, sort of know-nothing attitude, we're never going to look at what foreign courts do, is appropriate. But on the other hand, I think it's tremendously important that we realize that there is not some sort of transcendental body of law out there. That when we're looking at the American Constitution, we are indeed looking at the American Constitution, and that our Constitution has made choices that other countries have not.
Over here, standing.
My name is Ryan Shea, and my question is, if minors are allowed to buy mature and violent video games, then why are minors not allowed to see R-rated movies in the movie theater?
Well, not because of any legislation. There is no legislation doing that. That's a voluntary system of the movie industry. And indeed, the video game industry has a rating system of exactly the same kind. And one of the questions that the parties before us argued about was whether the rating system for video games was more or less effective than the rating system for movies. But in fact, there is no law that says that you can't see an R movie. The reason you can't see an R movie is because the industry itself has decided that you shouldn't be able to. And the video game industry has decided the exact same thing. And the question in the California case, which is a question that has not come up in the movies because there are no such laws, is whether in addition to a voluntary rating system, the state can come and put various restrictions on. But it's a great question.
We have time for a couple more questions, but I have to follow the microphone. Over here.
As Solicitor General, you were handed a position to argue, which may or may not have agreed with your own position. How did you handle that?
Well, I had a job to do, and that job was to represent the interests of the United States, and there are a whole set of rules and traditions that enable the Solicitor General to figure out what the interests of the United States are in a particular case. And as you say, sometimes that's not the position that I myself would have favored, or not the position that I would have reached if I had been a judge. Elliot referenced the dissent I wrote in this other Arizona case involving who had standing to bring a claim saying that there was an inappropriate establishment of religion. And the Solicitor General in that case argued against the standing of the parties. And in my dissent, I said that the parties did have standing, which means a right to sue, a right to bring a claim saying that there was an establishment of religion. So as a judge, I said there was standing. But I have no doubt that if I had been Solicitor General, I would have taken the position of that the Solicitor General in fact took, which was to argue that there was no standing, because that is consistent with a whole tradition that the Solicitor General's office has with respect to cases involving standing. And that's just, that's the job you take. When somebody asks you to be Solicitor General, if you can't do that, you shouldn't take the job. Your job is to represent the long-term interests of the United States, as the Solicitor General's office and others have defined those interests. And you better just put in a box and keep it there any other views you might have.
We have one final question in the back.
Thank you.
I think we have two in the back, so we can take two if they're very quick. Why don't you each give your question, and then Justice Kagan will respond to both of them.
When Sandra Day O'Connor was first appointed, it was pretty revolutionary to have a woman. Now that there are 3 women, I wonder if you could speak to how that's changed the court.
So I'll tell you what Sandra Day O'Connor says about this. she has been in the court on a few occasions this year, either to see former clerks of her argue before the court, or I think she actually came in a couple of the Arizona cases. There were 3 very important cases involving Arizona. I think she came in 1 or 2 of those just to see how her state was faring. And she's talked about this. She said she sat there as a spectator, and the way the bench works is that Justice Sotomayor sits on the far left of the bench, and I sit on the far right of the bench, and Justice Ginsburg sits near the middle of the bench. And Justice O'Connor said, you know, I was hearing women's voices coming from all over. And that was a remarkable thing to her, because I'm sure she, you know, remembers very well those days where she was the one and only. And so, you know, I think it's kind of great that has happened, and I think, you know, I'm glad to be a part of it.
And I think that's a great way to end, and we'd like to thank you very much, and we welcome you back to Aspen.